Okay, we are.
Yeah.
All right, well, it's not like you really got to do it, so, but welcome to board training. Go ahead.
My name is Megan Morris, and I'm an attorney with Cullewa Law Office in Missoula. I've been working, I know I recognize Patrick and Mark. You probably remember me. We did a lot of work on the bond projects from, I don't even know how long ago, 10? Oh, I was 17. I was thinking longer, but in any case, so I am familiar with your district, and worked with your former soup, and have worked with Dave actually, separately. So happy to be here, and yeah, we're just going to cover board orientation issues. You have there, or did they get them? They have there. Okay, so yes, I sent out to Christine packets to just guide us along. Happy to have questions throughout. I first want to point out, you do have a trustee code of conduct, policy 1511. It's not mandatory, but it is a good guide. And the reason why I think it's important to go over that is because it sort of does carry a lot of the things that I want to talk to you about. So the first one is just the basic, you do need to attend meetings. There actually is a statute in Montana that says if you miss three consecutive meetings or more without quote good cause or good excuse, it's actually a vacancy. So if you do have to miss a board meeting, make sure you notify them, and without getting too specific, give a reason so that you have a good excuse. It doesn't define what good excuse is, but I think as long as it's like, I'm done with this, I don't want to come, it would qualify. You want to make sure you are making decisions after full discussion, and that you're exercising your own judgment and not surrendering to the judgment of others or special interests. As a trustee, you have people in your ear constantly because they are seeking you to take action. As an individual trustee, you have no rights. You have no authority. You as a board can only act as a board. And so when you come to that board, you want to exercise what your judgment is and not carry through what someone else wants you to do. Certainly we want to see expression of ideas, but also it's important to remember that there's a hierarchy of communication. And there's a reason for this, and part of it is only certain things come to the board, and that's by policy and law. And so ensuring that the chain of command is in place, make sure that you're following the law and your policies. So when it comes to people coming to you with questions or concerns or want to talk about a specific issue, my recommendation is to always say, I hear you, but I think that this is best addressed by the superintendent. Or you refer them to generally your uniform grievance procedure, and I will go through that a little bit more, which is policy 1700. And so you just kind of have to, you can get uncomfortable, but you just kind of have to stop the conversations in the middle, because one, you don't want to be biased if it is something that ever comes before you, but two, there is a process. So it is uncomfortable, but say, I'm going to have to stop you. I would direct you to talk to superintendent. Likewise, as you as trustees, it's important that you go to Dave with concerns. It's not, within policy for you to go to a teacher specifically or a principal to talk about a concern. Your concern should be directed to the superintendent, who then can work on it. And if it's something that needs to come before the board, then it gets added as an agenda item. As the superintendent, Dave has the day-to-day authority. That's actually statutory in Montana, that the day-to-day operations are under the authority of the superintendent.
The board is the policy-making authority and oversight. You want to make sure that you're hiring best qualified people, but as the board, your role is to hire and fire, essentially. But you're looking at the recommendations from your administrative team who have more information than you're going to have. The reason for that is a lot of it has to do with confidentiality and rights of privacy. And we can't just introduce information about individuals at a board meeting. So if you have questions about, you see someone getting hired on a board agenda and you have questions, go to Dave, go to Christine. Those shouldn't be probably addressed in a board meeting because it makes it very difficult for them to respond because of the rights of privacy at issue. There's also some information you will never get. One example of that is you will never get to see criminal background check results. The law prevents us from sharing that. Now, I recognize that there's some conflicting newer laws that seem to suggest that can happen. But Montana Department of Justice, who controls that access, and they're following the law from the FBI, says you can't give that information to just anyone. In fact, you have to go through training and be certified to receive that information. Obviously, you want to avoid engaging in conflicts of interest. A lot of that in terms of our Montana laws relate to your own pecuniary interests. So if you have financial interest in something, you may have to recuse yourself because you can't take part in any decision to grant contracts. And any information that's shared with you, particularly in an executive session, but if you talk to Dave and Christine about, a specific issue, generally the confidentiality is going to apply to that. And that's very true for executive sessions. You cannot share information from executive sessions. So let's talk about,
Can I ask a quick question? What is an executive session?
it's closed session. So, under Montana law, the board can enter into closed session for two reasons. Closed session, executive session. The first is where the chair makes a finding that the individual privacy rights clearly exceed the merits of public disclosure. And that finding has to be made if that's why you're going to close the open session. The second basis to go into executive session or closed session is something called litigation strategy. So if there are litigation matters, or even if the district is looking to file suit, which actually this district has done, they have sued, it was a construction issue. To talk about that, a lawyer has to be present, but you can go into executive session. And as long as the other party is not solely a public party, so if you were suing the state, you wouldn't have the right to go into executive session. But if you're suing a private party, or even if you're suing the state and a private party, you can go into a litigation strategy session. So, again, I'm gonna say, since you were individually elected, that doesn't again mean you have any authority as an individual trustee. You don't have a right to come in and say, I want to see this file, I want to see this student's records. There is no individual right for any trustee unless the board approves it. Now, the board as a whole can review information, but generally that's going to have to be done in an executive session, which means you're going to have to close the session for individual privacy interests. And you also would have to give notice of to the people you're speaking about. So it does become really complicated in terms of bringing something up at a meeting that has a privacy interest and being able to talk about it right away because, like I said, you haven't given the right notices and you may not actually have the right information to go into executive session. So I do want to caution you that, like I said, you have to be really careful about bringing up some of these issues because of those privacy rights. The board as a whole can act, and like I said, the board can ask to see a personnel file. But an individual trustee without that authority cannot. So let's start sort of at the beginning as far as the authority under the law for school boards. So under our Montana Constitution, which was adopted in 1972, there's a provision that grants the supervision and control of each school within the district to the trustees of that district. And what we call that provision is local control. And Montana is unique in terms of giving that level of local control to school districts. Now, does that mean that the state can't do stuff? No, it doesn't. As we know, the legislature can pass laws affecting school districts. But it can be used to invoke other interests. It especially can work if it's two competing entities. So sometimes we see conflicts with, county commissions, local zoning boards. They want to come in and tell you what has to happen. Local control sometimes trumps their rights. About the only exception that they have is they can enforce building codes because it's a safety issue. But we had that issue come up many years ago in Helena, where a school actually became condemned because it was structurally unsound. But it was an old school, and the district said, we're gonna have to demolish the school in order to build a new one. And because of its historic nature, a group did sue the school district and say, you can't destroy that. It should be subject to historical preservation. And it was litigated, and the school district won because they said, you don't have the right to govern what we do with our property. So that's an example of where local control can trump. The Constitution also states that local control includes providing a basic system of free quality schools. Where that can get interesting is that's also a constitutional requirement of the state, and there's been a lot of litigation. It's school funding, as to the appropriateness and sufficiency of school funding. And there have been multiple lawsuits that have happened, certainly to challenge school funding. So your actual duties are defined by statute 20-3-324. These duties include, like I said, hiring, dismissing, transferring, assigning employees. Mostly it's about those hiring and dismissing. Directing employees through the superintendent. Again, you individually or you as the board can't direct an employee. You can direct the superintendent to say, this is what we want to happen with these employees. You have the right to delegate authority to the superintendent for ongoing management. So the one that comes to mind immediately for that is under your purchasing policy, there's a provision that allows your superintendent to approve contracts up to a certain level. Is yours 80,000? Or is it 10,000? Yeah. Every district is different, but there's a financial limit, you say, where you don't have to bring this contract to the board. You can act and approve that contract. If there are emergencies, the board has the authority to take whatever actions are necessary to carry out the mission of the district. One of your main roles is to adopt and evaluate district policy. Now, I think it's interesting that, you are supposed to be evaluating policy and the effectiveness of policy, but a lot of what you have in policy, you don't have a choice about. So even if it's not effective, you may be stuck with it because that's a legal requirement. You're going to want to make sure that the district operations are efficient. You approve the district's budget. You probably already went through that not that long ago. You can be doing reductions in force for employees. One of the big things you do in the spring is you're setting levies. And At any point in the year, so levies are generally in that May election, but at any point in time, a district can run a bond election. I don't think I think your last one was when you did the construction, and I think you guys just ran one, right? That wasn't successful, right? So that's the role of the board, to set those bond amounts. Again, board is the one that enters into most contracts, especially the ones over that threshold. And you're setting your educational goals for the district and making sure that the superintendent and the staff pursue those goals. And then also through, board meetings and board communications, as a board, you can be communicating district goals and to students, staff, and members of the community. One that's not mentioned that is something that's solely the responsibility of the board, just like hiring and firing of staff members, is only the board has the authority to expel a student. Only the board has the authority to, the language is exclude a student from participation in high school extracurricular activities for misconduct. Only the board has the authority to deny the right of a student to walk across the stage of graduation. So those are some specific duties that, like I said, belong just to the board. So that policy piece is a primary piece that the board engages in. You are gonna, through policy, set public goals. You're also gonna do this through something called your integrated strategic action plan, which I think usually gets done winter time. Where I see it most relevant now is, it is the best place to put in some standards for out-of-district enrollment. So while the law now says accreditation limits can be a basis, exceeding those can be a basis to deny an out-of-student application, accreditation limits don't apply to all district classrooms. And so your integrated strategic action plan is where you can say, we don't want to exceed certain classroom limits in, some special ed programs or something like that. So that's where it is, and it's reviewed every year. You're going to be setting policy, and like I said, to the extent you can evaluate the results, you're going to. And by that I mean, again, you just may not be able to change the policy even if it's not effective. Unfortunately, there's all sorts of things that we see that are not what I would call effective that we can't change because the law requires us to have that policy. So through your integrated strategic action plan, you're also engaging in continuous school improvement. And you're gonna have that aligned to your strategic action plan. And it's also gonna contain your graduate profile. Your administration is the one that largely is responsible for drafting that. So there's no requirement that you as the board draft it, but you're certainly involved in the process. So I do want to review a couple of policies that I think are specific to your roles as trustees. So again, policy 1240 relates to your duties as individual trustees, and that you have no legal authority and that you can only act as part of the board. It also covers the fact that if you act outside the scope and course of your legal authority, you don't actually have protection. You're not immune from liability in that situation. So if you go out, where I can think of this coming up is you go out as an individual trustee and make a public statement in your role as a trustee, or claiming to be as a trustee, that maybe is defamatory. That could result in personal liability. Where you could also potentially, I hope this never comes up, I have yet to see it, is, revealing confidential information from, an executive session or that you've otherwise been privy to, as a board. So, again, you're developing policies and how your policies, that's 1310, are adopted and amended. I don't believe you guys have a multiple layer adoption, right, where you have first reading, second reading?
Yeah.
We have first readings only for legal,
Okay.
required, and then we do second reading for optional.
Okay, so, that means you need to follow it. If there's something that comes up, there is a mechanism to suspend policies, and that's sometimes where, emergency action occurs, is there's a motion to suspend a particular policy. So that can happen. But there is no requirement technically under the law that you have first or second readings. Many districts have adopted upon, or effective upon adoption. Policy 1400 establishes your board meetings. So you have regular meetings, which I believe you have later tonight. And then you have what you have right now, which is a special meeting. Special meetings are not usually like we're here doing board training, but usually they're something specific. So a special meeting can be convened by any two trustees with 48 hours notice. And then in order to proceed, there would have to be a quorum of trustees. For your regular board meetings, the law does not have that 48-hour notice. Instead, it requires reasonable notice, but that's generally been interpreted as that 48 hours. So I've never seen a district get caught for having more than 48 hours or 48 hours exactly. There are situations, emergencies, where you can proceed without the 48 hours notice. They're few and far between, but I have seen them come up. For instance, I don't know if you declared an emergency for what happened with your middle school. But sometimes districts have had to, because of facility issues, floods, things like that, they've had to close facilities, and that affects your time for students. And if you don't have the sufficient amount of time for accreditation, then that can get you into trouble. But there are exceptions where if boards pass emergencies, you get some sort of leeway with that. So that can sometimes be where that can come up. Your school board, or the next one is public records. Montana law does afford the right to public records. And as an individual trustee, if you make a records request, it would actually be treated as a public record request. You would be treated not as a trustee, you'd just be treated as any other member of the public. So most records are going to be public unless they're confidential. Confidential records include student records, most employee records, and I'm going to come back to that. And then the one that luckily I've yet to see, but makes sense when you think about it, are safety plans. Specifically, like what are your plans for evacuations of students for lockdowns, that kind of stuff. Because it makes sense, you don't want that information revealed to the public. 1420 talks about your school meeting procedure. It talks about developing an agenda. So generally your agenda is set usually between your superintendent and board chair. But trustees can certainly ask for items to be added. That is up to the board chair to make that final decision. Just like any member of the public can ask for an item to be added to the agenda. It sets probably a time frame for when those requests have to be made. It also talks about minutes, your quorum requirements, the issue of recording. That was something that happened as a result of the 2023 legislative session. They had previously had public boards subject to that, but then in 2023, they added a requirement that it's applicable to school districts. So unless you're a tiny, tiny school district, you're having to record and make available the recordings. What the law doesn't require though is we don't believe that it requires you to record committee meetings and It doesn't have anything about, making meetings available, on Zoom. That became a big thing during COVID, where districts were posting links to meetings and making them available or giving individuals the right to comment electronically. The law doesn't cover that. And so even if you have your meeting available live, there is actually no requirement that you allow public comment electronically. Audience participation, that's governed by policy 1441. It does talk about that we have a Montana constitutional right to know, and Montana right to participate. But both of those can actually be overcome by rights of privacy. So it's largely the board chair's responsibility to control public comment. And so beyond issues of privacy, public comment is permitted on items of public concern. If it's not of public concern, it actually can be cut off. So things that are not of public concern are individual gripes or complaints, because there's a complaint process for that. Certainly litigation. I realize you're a public entity, but that doesn't mean you have to have public comment on ongoing litigation. If you have actual grievances going on, public comment is not appropriate for those issues. There's also the right to put reasonable time, place, and manner on public comment, meaning you can put a 3-minute limit. You can state that individuals can only speak once. And certainly, there's decorum rules you can place. You can stop someone from making threats, obviously, yelling and screaming at you, engaging in vulgarities. My recommendation is, the board chair calls them out of order and reminds them to stop if they don't. Worst case, you stop the meeting and you call law enforcement. That has come up, not to my familiarity in this district, but in other districts where things have gotten ugly and law enforcement has to get called. 1511, we've already covered, that's your code of ethics. Like I said, it's not binding, but it's a good guide. 1512 is your conflict of interest policy, and it talks about the legal conflicts of interest. That said, if you are afraid of the appearance of impropriety, you may want to think about whether it's something you should recuse yourself so that it's not questioned. It may not be legally required, but I think it's something you should question. And I would say talk to your board chair as your first resource as to whether you think that should happen. And if necessary, you can seek legal counsel with Christine. There's options with respect to whether you think you should recuse yourself. 1520 is that policy telling you about the chain of command. And like I said, anything from the board or you as trustee should go to the superintendent. Just like if staff or principals want to make comment to the board, that comes through the superintendent. So the superintendent is your funnel for communications. And it's the same thing if individual members of the public or parents come up to you and say, I need to talk to you about this issue. You have to say, again, I'm sorry, I understand your concern. I'm going to direct you to talk to the superintendent, or if it's an issue where they have a grievance, then you would suggest that they start at level 1, which is to talk to the person with whom the grievance is about. Uniform grievance procedure is sort of the heart of the grievance procedure. If someone has a complaint now, not all complaints fall under the uniform grievance procedure. In order to proceed, someone has to allege a violation of state or federal law or board policy. So just because they're unhappy with something does not give them the right to bring a uniform grievance under your policy. Like I said, they have to allege violation of state or federal law or board policy. There's also certain things that are not subject to 1700. So if you have a staff member who wants to file a grievance relating to their employment, and their employment is covered by a collective bargaining agreement, their collective bargaining agreements contain grievance procedures that are outside that process. There's also 2 legal or two types of complaints that are not subject to the uniform grievance procedure. Title IX, sexual harassment. So someone alleging they have been sexually harassed under the law, there's an entirely separate policy that covers that. And those complaints are probably never coming before the board. The second one are allegations of disability discrimination. Those are also subject to a separate grievance procedure because that's what actually the law requires. If someone is alleging, gender discrimination or sex discrimination, meaning the one that often can come up in sports, obviously, you're giving more money to the boys' teams than the girls' teams. That's not sexual harassment, and that would be handled by policy 1700. The final one that's not covered is someone complaining about the content of a special education plan. That doesn't come before the board. There's an entire separate process under the Individuals with Disabilities Education Act that covers how parents challenge those issues. And that's not something that ever comes before a board. So again, you're supposed to evaluate results, but a lot of times about, you can evaluate them, but even if they are determined not effective, the one that comes to mind is Title IX. As far as a process, I think it's a process that is cumbersome. I don't think it's an effective process, but it's the process we have to follow under federal law. So even though, if someone says this is taking forever, we don't have a choice about that. So how does this actually look in process or in practice? So one of the things that you have to do, and I'm gonna refer you to Kathy for questions, for school finance. Montana School Finance, I think, it's a pretty complicated process, which you may or may not have figured out during your time as a trustee. We have a pretty complicated funding system, and I think there's very few people in the state that actually understand it, but certainly, look at Dave and Kathy as far as your best resources for school finance questions. As a board, though, you are adopting your budget, and you do have that responsibility to engage in ongoing monitoring. Where are you budget-wise? Are specific line items going over, going under? You're approving transfers. It's an ongoing process. You probably have budget issues come up at every single board meeting. Your 7,000 section of your policies talk about financial operations. It's within that section that your purchasing policy, like I said, that talks about those purchases that the superintendent can make as opposed to ones that have to be board approved. It also talks about, your requirements under the law for procuring services. When you have to bid, there's certain specific rules for federal or for bidding out or solicitations using federal funds. So that's all governed by your policy 1700. One of your other main roles beyond policy is you hire the superintendent to effectuate the policies and goals of the district. So as a board, you are expecting the superintendent to essentially act as your chief executive officer. And again, that your superintendent is the board's liaison to staff, to students, to the community. You do annually evaluate your superintendent, and you do have a requirement if your superintendent's contract is out that you make a decision on that by February 1st. So if it's a year where, because contracts can go between 1 and 3 years, if it's a year that the superintendent's contract is up, you have to make a decision by February 1st. As to what is going to happen with the superintendent. The superintendent does not have tenure. That's the only role that's a certified role, meaning it's a licensed role that isn't entitled to tenure generally. So that's why it's a contractual issue as opposed to a tenure issue. The superintendent has the right to expect certain things from you. accept that policy is the core of governance, commit to support the superintendent's implementation of board policy, annually evaluate him or her, operate efficiently and with integrity, refrain from advocating for special interest groups, and refusing to yield to external pressures that challenge the role of superintendent. Winds can change, and people, if there's unpopular decisions in the district, sometimes the weight of that falls on the superintendent. You have to back the superintendent you hired for at least the term of the contract. As far as what you have a right to as a board expect from the superintendent is that the superintendent will communicate clearly in writing and orally, act with integrity, demonstrate competency in finance, management, school law, and personnel, ensure that there's accurate evaluations of staff under the superintendent's supervision, making sure the board and the public are informed, and bringing educational issues for you as a board to study. So in your role as trustees, there are certain issues, and these are where, like I said, you may have people, saying in their ear, I have these issues. I'm upset about this teacher, I'm mad about this issue. And that's where sometimes that's part of that 1700 grievance procedure. Things only end up at the board if they've gone through a process. So level 1 is starting with usually the person about whom the grievance is and trying to resolve it informally. If that doesn't work, then there's level 1, which generally involves an investigation by usually the building principal. Level 2 is, or is it level 3? The next level would be the superintendent. And then things only reach the board if either it's about the superintendent or it's gone through that process and meets those basic requirements of alleging a violation of state or federal law or board policy, except for the issues I mentioned, and was timely, because there is a timeliness requirement in the board of generally it has to be filed within 30 days. So there are issues that can come up that you may never actually see as a board, because it hasn't followed the right process. And people can get really mad if things are dismissed without actually following the process. Your board chair actually does have the authority, if it doesn't meet the minimum threshold requirements of being timely or alleging a violation of state or federal law or board policy, to dismiss it if it reaches his level. So that is something that the board chair can do. However, if it is rightfully in front of the board, then generally there'll be a board meeting where, especially if it relates to something that's confidential, it's going to be in closed session. Two of the other things that you see as a board, because like I said, these are actions exclusive to the board's authority, are staff terminations and student expulsions. I'm gonna come back to the issue of closed session with staff because that's actually a pretty complicated issue, but generally, student expulsions are done in a closed session because that student has a right to privacy. That student does have a right to waive that right of privacy, in which case it is open. But you are only gonna be presented with information that you would have a right to see. So if a student expulsion comes before you, you probably are only gonna see some of that student's information because federal law, specifically the Family Educational Rights and Privacy Act, says you only get that information that's necessary for you to make a decision. You have to have what's called a legitimate educational interest. So the student's first grade records you may never see if the student is in 7th grade and is being brought for you for an expulsion. And there may be issues you hear about as trustees relating to students that may never come before you. And understand there's a legal basis for why it would never come before you. So sometimes, yes, you have to take information on trust. And you may want more information, but because of privacy interests or because of, like I said, federal law, the administration can't provide you more. And I understand that that's really frustrating. But unfortunately, like I said, we have these limits of the laws that prevent sometimes full disclosure of information. Staff terminations can also come before you. Those are really tough. And if it's for a tenured employee, that's gonna be a hearing. What you may get more frequently, at least towards the end of every school year, are recommendations for non-renewal of staff. And under Montana law, and depending on collective bargaining agreements, so with respect to teachers are essentially considered probationary employees for the first 3 years of their employment. They have a right to finish out the contract, so meaning whatever length of contract they're given, and it's an annual contract at most. And they can be terminated or non-renewed, so it's the next year that they're non-renewed for any legal reason essentially, without having a board meeting. So what you may see as a trustee is the superintendent recommending non-renewal of teachers and saying, I'm recommending non-renewal, and then providing you no other information. And a lot of that has to do with privacy rights. It's not because there used to be a concern that would create a right of a hearing, that's not it. It's largely because of privacy rights related to that employee. So that is where you're gonna have to trust your superintendent with the recommendation that's being made. But again, if you have questions, reach out beforehand. Similarly, your classified staff, I believe you do have a union for your classified, right? Your classified staff, they do have a probationary period. Same rules apply during that probationary period. I'm not sure if it's 6 months or a year, but it's probably within there. After that, you can only terminate for good cause, just like a tenured staff member. That is generally where that right to a hearing attaches, is anytime you have to terminate because there's good cause, there is a right to a hearing, because from a due process perspective, you're depriving someone of a property interest. That's the legal justification, is that you have the right to property, and a contract is property. So if you are stopping a contract midway, that gives the right to a hearing.
Wait, real quick. If I remember correctly, and this from Via's stuff too, when we were doing the non-renewals, if we ask for stuff, does that open up the potential for hearings? Because she mentioned that before, and like when we were, because there's, well, we wanted to know stuff, and they bring that up, and it's like, well, you're potentially opening yourself up for a hearing with that.
No, it's not. Like I said, where it generally opens you up is a privacy right. So could the board ask for a reason? Yes. If the person's there, you could go into executive session.
Yeah.
And that's where so it's not a hearing, it would be generally an executive session where there would be a discussion in front of that employee about the reason. But it's not like a prove this or prove that, like it would be for a termination hearing.
And the employee can waive that executive
Yes.
session too, so that
Yeah.
you end up in an open board meeting,
Right.
having a discussion, if that's what they choose.
We do advise, I don't even advise using the with or without cause language because I think it's confusing. I say just pursuant to 20-4-206, because that's the statute that allows the non-renewal of non-tenured staff. Do make sure you give written notice of that decision by June 1st. Particularly important because if they're in that 3rd year of employment and the issue is about that 4th consecutive contract, failing to give that notice by June 1st means the person has tenure. And that actually happened several years ago in Victor, where had someone that was, someone that they wanted to non-renew in that tenure contract year, and the person conveniently moved, didn't tell the employer, and so the district sends out the notice, and the employee goes, didn't receive it. And it went all the way to the Montana Supreme Court, and the Montana Supreme Court said, yeah, this person has a contract because they didn't have the notice in hand by June 1st. And there was no requirement of the district for the employee to update their address. So, make sure you get that notice in hand by May 1st if you need an non-renewal, because it does matter. So under Montana law, we have two competing constitutional provisions. One is the right to know, which is that right to watch what you as a board are doing. As well, that's observed deliberations, as well as their public record rights. But under that constitutional provision, it says, except in cases in which the demand of individual privacy clearly exceeds the merits of public disclosure. So those inherently confidential issues generally related to a privacy interest can be closed from the public. That right of privacy, though, can sometimes be trumped by what's called compelling state interest. And that's a constitutional analysis, it's a very complicated analysis, but when it comes to employees, there's some things that we do know because there's a lot of tension between those two constitutional provisions. And as a result of that tension, there's a lot of litigation. In fact, I think there was a case that came out in April of 2025 relating to deliberations in the governor's office, I think about appointment of judges. And they were trying to close that down, and the Montana Supreme Court said, no, you don't get to close that down. So, we may have, like I said, public records requests, unless it's requesting confidential information, you don't have to give it up. Unless they waive that right, generally students have a right of privacy. Employees, though, is a much more nuanced question. And that is because through this line of cases, I apologize. The smoke is getting to me. Since the constitutional amendment was passed in 1972 about the right of privacy, there have been so many cases. And through that line of cases, the Montana Supreme Court has said that many public employees in their roles occupy what's known as a position of public trust. And so if that employee engages in misconduct, there's often no right of privacy because of that public trust. That even included, now this was an elected official, but there was an elected official, it was a county commissioner, who was arrested for a DUI. And they tried to withhold the information related to the DUI, and the Montana Supreme Court said, no, because it still impacted his ability to be effective on the job, even though it actually wasn't related to his duties as a county commissioner. So I don't know how that would work with an employee, because in order to have good cause to terminate an employee for outside conduct, you have to be able to connect it to their job. But there is the possibility that there may not be right of privacy. Certainly with respect to misconduct that is found by a public employee, there's likely no right of privacy. What does that mean? It means sometimes misconduct hearings to terminate employees are done actually in open session. And the reason I say sometimes is, in a lot of these cases though, we have competing rights of privacy. So if the misconduct relates to a student, then there may be situations where boards have to go in and out of closed session. Because if the individual doesn't have a right of privacy, but the student does, anything related to the student is done in closed session, anything related to the employee is done in open session. There are other cases where those issues are so intertwined that you can't separate them. In that situation, we probably would go for a closed session. And like I said, usually that's a student-only issue, but, and this doctrine has been applied to school employees. And the last case that there's two cases I'm aware of. One was in Billings many years ago, involving two teachers found in the, I think it was the teacher's lounge, on a couch, engaging in some extracurricular activities, and was caught by a student.
Ooh.
And
No
Yes.
HSI warning? No HSI notice, and sexuality instruction.
Oh, no. No, luckily it was before that. But understandably, the Billings School District, sought to, discipline these two staff members. And because it became well known in the community, the news media came looking and said, we want to know who these people are. And the Billings School District did something where they actually filed all of the information with the court and said, you know, the employees are asserting a right of privacy here. We realize the media is saying you have a right to know. Court, you decide. The risk of that is they could say, well, you should have known this and you then have to pay attorney fees. But it's actually something where if it's unclear, it has worked. But the court ultimately decided that those employees had occupied a position of public trust, and therefore their misconduct was revealed in public. The other issue that came up, and it also went to the Supreme Court, but it was more about attorney fees, was there was an employee of Missoula County Public Schools many years ago who was in, I think she was a food services director. And actually it related to things happening after she left the district down in Ravalli County, questioning some potential financial improprieties. And again, the media came calling and said, we want to know what happened in Missoula County Public Schools. And so we did the same thing that Billings did. We asked if the former employee, do you believe you have a right of privacy? The person said yes. So we said, we filed an action in court, said, court, you decide. And there were so many records in this employee's file that they ended up having to parse out. So anything that was in the employee's personnel file, except for like discipline relating to the misconduct, was actually withheld. So employee applications, those are still private. This matters for you, superintendent evaluations. So your evaluation of the superintendent can be done in executive session if the superintendent asserts a right of privacy, which they have a right to do. Superintendent has a right to waive that, but they don't have to. It's entirely the superintendent's choice. If they do not waive it, it's held in executive session. So whatever happens as a result of that evaluation is actually confidential. Anything relating to family issues, health issues, that obviously remains confidential. But if it relates to employee misconduct, then often that does get disclosed. So any termination of public employees, school teachers, classified personnel, other administrative personnel that relates to misconduct generally would be held in open session. Now, that can be effective to talk to sometimes them where they don't want it public. So might get a resignation out of that. We have seen that happen. Usually that's going to involve legal counsel to help navigate those issues. If though it relates to performance, meaning you're just not doing your job, we want you to do your job, you're not meeting our expectations, that is going, just like an evaluation is confidential, that actually would be held in closed session. So performance, confidential, misconduct, probably not. So, just to kind of finish up, remember, if you're asked to speak to the media, you certainly can, but you can't unless you've been authorized by the board to speak on behalf of the board. Anything you hear, especially in an executive session, is confidential. That includes, in particular, if you have a lawyer that's in a litigation strategy session giving you legal advice, there's an attorney-client privilege that attaches to that. So you want to recommend or respect that confidentiality. Refer your issues, like I said, just tell people. gotta go to the superintendent. Follow board policy. Those are your two safe answers. I gotta stop you, I'm gonna recommend you talk to the superintendent, or I recommend you look at board policy 1700, or like I said, if it's a Title IX issue, look at your board policy, I think it's generally 3225. If it's a disability discrimination, I cannot remember the policy number, but you do have a policy and a procedure for that. If you have questions, there are answers. So first, go to your board, other trustees, go to your board chair. If they don't have the answer, go to Dave, go to Kathy, go to Christine. Look at your board policies, be familiar with them. That answers a lot of questions. Be familiar with your CBAs. When you're dealing with those issues of privacy, you have to be really careful about not in a public meeting using student names. That would be a violation generally of their student rights, unless you're getting up and saying, way to go, this student, for winning the state championship. Or, winning this award. That's okay. But anything that is neutral or negative about a staff member or a student, you can't talk about in open session. And you can't use a student's name or a staff member's name when talking about something, because putting that together, if that reveals the identity, then you're still engaging in a breach of that confidentiality and right to privacy, potentially. So again, if you have questions or concerns about an employee specifically, go to Dave. He can search for the answers. If there's an issue you think the board as a whole should be addressing, go to your board chair. When you come to vote, ask questions. There's usually a period of time before you vote on matters that allows for board comment or questions. Feel free to ask the questions at that time, but again, make sure that those questions don't invade those rights of privacy. When you come in, be informed to the extent you can be, especially when it comes to terminations of student matters. You may not have any information before you come in because we can't send out student records in advance. So that information may come to you in a board meeting, in which case you're given time to review that. So it's 6:15, which was about when I was gonna stop. Are there questions? My dad was a former trustee. Oh, yeah.
Why do we, or do we not provide this same education to our admin staff? Because it feels to me like they should know it too.
I think we can look at Dave.
For sure.
Think about how much, I'm just thinking about the 100,000 different times that I've been approached by somebody, and it's probably inappropriate as well. A principal.
Yeah.
So, I think it's all out of ignorance, but it's still problematic, especially if we have a tighter line to ride. I think there's a lot of other teachers and much of the admin know-how, the role of a board member actually functions either. Probably that education would probably be helpful.
We got done through PIO.
Could we,
Would that be legal?
to do a training?
Training on this?
Yeah, we could, yeah. We could, there's lots of different ways.
Are we in closed session right now? Okay.
You're on live.
Okay.
But yes, there's lots of ways to provide that. That level of information.
Is that reasonable?
I think it's reasonable. It just clarifies what everybody's role is.
I think that would be helpful for everybody. It would avoid a lot of problems, probably.
Perfect. All right, any other questions for Megan? Thank you very much.
Thank you.
Thanks, Megan. Thank you, Megan.
All right.
Why don't you love